Welcome, curious minds, to another deep dive. Today, we're plunging into something that feels pretty straightforward on the surface, but actually holds some surprising risks. We're talking about H-1B visa compliance, specifically the tricky parts around part-time work. Imagine you've landed that amazing job, or maybe your company needs to make some temporary changes, perhaps cut back hours for a bit. For H-1B holders, what seems minor, like fewer hours for a while, well, it could quietly put your whole visa status at risk. So our mission today is to pull out the really crucial bits of knowledge from our sources, articles like H-1B compliance, navigating part-time work risks, some real USCIS case examples, detailed guidelines. Basically give you, our listener, a shortcut to being informed and, protected.
And it really is critical. What we've seen again and again in the research is that these seemingly small deviations from what's on your official approval, they can have really significant long-term consequences. We want to go beyond just listing rules today. We're aiming to help you understand why these regulations are so strict and why being meticulous, really careful, is just vital for your whole immigration journey.
Okay, let's unpack the main problem right away. The fundamental risk is simple, but it gets missed so often. Your H-1B approval, that's on Form I-129, the petition for a non-immigrant worker, and also the labor condition application, the LCA, it specifically lists your hours as full-time, usually 40 hours a week. If you end up working fewer hours than that, you're technically violating the terms of your visa. And here's the kicker, the really important insight. This holds true even if your employer keeps paying you your full salary.
Exactly. USCIS isn't primarily looking at your paycheck amount. They're looking at whether you're sticking to the specific job conditions, the hours, the location, the role that justify granting you the visa in the first place.
Right.
Now, what's interesting here is the timing, the difference between visa periods. Our sources are pretty clear. Part-time work, it's generally allowed, totally fine, during your STEM OPT or maybe before your H-1B actually starts. So any hours you work before that H-1B activation date, they're usually exempt from this specific rule we're talking about. But the moment that H-1B status becomes active, you must work according to the full-time terms in your petition. That's precisely where people can accidentally get into trouble thinking, well, I'm getting paid, so it must be okay.
That really is the counterintuitive bit, isn't it? You'd think, money's coming in, I'm good. But no, it's not just about the pay. It's about fulfilling the exact documented terms. Your H-1B isn't just a general permission slip to work. It's tied very specifically to that job, those hours, that location. So, okay, beyond the immediate, like, am I compliant right now? Question. What does this mean down the road? For long-term goals, this is where things can really start to ripple outwards and cause bigger problems later on. We need to talk about how this affects future filings. Say you want to change employers, transfer your H-1B, get an extension, or, the big one, apply for a green card. USCIS, that's U.S. Citizenship and Immigration Services, they're going to look very closely at your pay stubs and your employment records, rigorously.
Absolutely. And if those records show periods where you worked, say, 20 hours a week, but your approved H-1B petition says 40 hours a week,
right,
well, that's a major red flag for them. It signals a potential violation of status. And that can lead to some serious headaches. Delays, definitely. Requests for more evidence, or RFEs, which slow everything down. More scrutiny on your whole case.
Or even outright denial.
There are even denials, yeah. And it's not just the employee who's potentially in trouble. The employer could also face penalties for non-compliance. So understanding and following these rules, it's crucial for both sides.
Okay, to make this less abstract, let's look at some real examples our sources highlighted. These really bring the risks home. Imagine this scenario. A software engineer, like many people did during the pandemic, ended up working remotely from India for about 4 months. Her H-1B was active, approved for work based in the US. What happened next?
Well, unfortunately, USCIS issued what's called a Notice of Intent to revoke a NOIR for her H-1B visa.
Wow.
And the key here is how they found out. Her U.S. payroll records didn't show any U.S.-based work for that 4-month period. Even though the employer kept paying her full salary, the fact that she wasn't physically present and working in the U.S. as per the petition, that was seen as a material change, a significant deviation.
That really hammers home the point, doesn't it? Being paid isn't the only thing. For USCIS, the H-1B is tied to a specific job, under specific conditions, including location. Change that materially without telling them. You're changing the deal.
Precisely. The location is just as material as the hours or the job duties in many cases.
Okay, so that case focused on location. What about just the hours? Another situation our research flagged involves someone trying to transfer their H-1B. Pretty common move. But before applying for the transfer, this person had worked part-time maybe 20 hours a week for about 3 months at their previous job. Why? Because the employer had some financial issues, needed to cut costs temporarily. Seems understandable, right?
Understandable, perhaps, but problematic for immigration purposes, if not handled correctly. What happened? The H-1B transfer was denied.
Denied, just for that.
Yes. The reason USCIS gave was clear. The pay stubs submitted from the previous job showed only 20 hours per week, while the original H-1B petition was clearly approved for 40 hours per week. The crucial mistake. The previous employer hadn't filed an amended LCA or an amended H-1B petition with USCIS to formally reflect that temporary reduction in hours.
Ouch. So even if it's temporary, even if it's the employer's decision due to hardship, if you don't file that formal amendment, it can basically invalidate your status in the eyes of USCIS when they review it later.
That's the risk, yes.
Yeah.
It really highlights why being proactive and documenting everything correctly, including filing amendments when needed, is so incredibly important. You can't just assume temporary changes are okay.
Okay, so this is probably making some listeners a bit nervous. What can you actually do? How do you protect your status? Let's move from the risks to the solutions, the practical steps.
Right, let's get into the what-to-dos. Based on our sources, there are 3 main protective measures. First, and this is huge, documentation. Keep everything. Pay stubs, emails, letters, work logs. We'll get into the specifics of what to keep in a moment because it matters. Think of it as building your evidence file. Second, maintain transparency, especially if your hours were reduced because the employer faced difficulties. Make sure there's official communication about this. Get it in writing emails, official memos, record it clearly. Don't let it be just a verbal agreement.
Makes sense. What's the third?
Third, consult an immigration attorney. Seriously, they are your best friend in navigating this. They know the rules inside out. They can tell you definitively if an amendment is needed, help you file it correctly, or advise on how to document things properly if an amendment isn't strictly required. But the situation is, a bit gray.
So documentation, transparency, and getting legal advice. The bottom line from the source material seems to be before your H-1B starts, like on OPT. Part-time is usually okay. But once that H-1B clock starts ticking, you must stick to the full-time terms in your petition. If you have to deviate, even for a short while, you need proof. Proof it was temporary, proof your employer approved it, and proof you were still compensated according to the underlying conditions if possible.
That sums it up really well. Documentation is your safety net if things change.
Now, amendments keep coming up as the formal fix. Let's dig into that a bit more. When exactly is an H-1B amendment required? It feels like a gray area sometimes.
It can feel that way, but there are specific triggers. USCIS requires an amendment when there's a material change in your employment.
Material change. Okay, what counts?
Well, the big ones are a significant change in hours, like going from full-time to part-time, or actually even part-time back to full-time if the original approval was for part-time. That change needs documenting. Also, a change in work location. Moving to a new city, or even starting to work remotely full-time from home if your petition specified an office location, especially if that home location is in a different metropolitan statistical area or requires a new LCA wage determination.
Yeah.
And definitely working from outside the US, like the India example.
Right.
And of course, a significant change in your job duties, or if the company structure changes, like through a merger or acquisition where your employer entity changes. These all generally require an amendment.
Okay, so if one of those happens, what paperwork are we talking about for the amendment? Is it starting all over again?
Not quite starting from scratch, but it does involve key documents. You absolutely need a new labor condition application, the LCA, filed with the Department of Labor. This new LCA must reflect the updated information, the correct hours, the new location, whatever the change is. Then, you file an amended Form I-129 petition with USCIS. It's crucial to include a detailed cover letter, usually from the employer's immigration lawyer, explaining why the amendment is being filed, what's the reason for the change, employer hardship, new role, relocation. And while maybe not strictly mandatory on the form, it's highly recommended to include supporting evidence like recent pay stubs showing the current situation, maybe work logs if hours are complex. It helps build a stronger case.
Got it. So the process is new LCA first, then the amended I-129 petition with USCIS, explaining everything clearly.
Correct. And especially for situations like remote work or temporary non-working periods, keeping proof of continued payment, even if less work or no work was done for a short time, can be helpful to show the employment relationship continued.
Since we keep coming back to documentation, let's really nail down that paper trail. What specific things should people be saving, and why is each piece important? Our sources were very clear on this.
Absolutely critical. Think of this as your personal compliance file. First, pay stubs.
Yeah.
Not just recent ones, but ideally for your entire H-1B period with that employer. Why? They show consistent employment and pay, even if hours dipped temporarily, demonstrating the employer intended to keep you on.
Okay. Pay stubs. What else?
Work logs or hours trackers. If your hours fluctuate or if you ever worked less than full-time, having your own record of hours actually worked can be invaluable if USCIS questions it. It provides concrete proof.
Good one.
Third, employer emails or official letters. Anything in writing that documents why hours were reduced or approves remote work or explains any temporary changes. This provides context and proof of the employer's awareness and agreement. Verbal agreements are risky.
Right. Get it in writing.
Fourth, if relevant, things like 221G letters from a consulate or other consulate documents. If you are stuck outside the U.S. due to visa processing delays or travel bans, these prove why you weren't working in the U.S. for a period, showing it wasn't just abandoning the job. Fifth, basic but essential. Your stamped visa and your I-94 arrival departure record. These confirm your entry dates and authorized period of stay. And finally, if you did consult an immigration attorney about any of these issues, keeping copies of legal memos or written advice they provided can further strengthen your case if USCIS later asks for clarification. It shows you sought expert guidance.
That's a comprehensive list. It really paints a picture of how building this file proactively as you go can save you massive headaches later, especially if you're thinking about that H-1B transfer or starting the green card process soon. It's like insurance against RFEs or denials.
Exactly. It's all about anticipating what USCIS will look for and having the answers ready, backed by evidence.
Okay, this raises a really important, maybe slightly uncomfortable question for some listeners. What if you're hearing this and thinking, uh-oh, I already had a period where I worked part-time or maybe worked remotely without an amendment and my H-1B was active. What can someone do now about a past deviation?
That's a really common scenario and a valid concern. First thing, don't panic, but do take it seriously. Let's break it down based on the sources. If that period of part-time work happened before your H-1B was activated, say, during your OPT or STEM OPT period, you're likely okay. As we said, part-time work is generally permissible under OPT rules, so breathe easy on that front.
Okay, good news for some. But what if it happened after the H-1B started?
Right. If the deviation occurred while you were on active H-1B status, you need to be proactive. The #1 recommendation is talk to an experienced immigration attorney immediately, ASA. They can assess your specific situation. Depending on the details, how long ago it was, the reasons, the documentation you have, they might suggest different strategies.
Like what?
Well, one possibility, though it requires the employer's full cooperation, might be filing an amendment now, sort of retroactively explaining the past situation. This is complex and not always feasible or advisable, but an attorney can guide you. Another approach might be to prepare a detailed explanatory letter signed by you and maybe the employer to proactively include with your next immigration filing, like an H-1B transfer or extension or your green card application. This addresses the discrepancy head-on before USCIS flags it.
Okay, proactively explaining it.
Yes. And if you're really unsure what USCIS even has on file about your past employment, you could consider filing a Freedom of Information Act request, a FOIA request with USCIS. This lets you see your own immigration file.
Ah, interesting.
But the absolute most important thing is to avoid future risks. Ensure from this point forward, your work hours and location always match your current approved petition, or get any necessary changes formally amended before they happen or as soon as possible.
And on the flip side, what are the big do-nots? What should people definitely avoid if they realize they had a past issue?
Crucial point. First, do not submit conflicting information. When you file that next H-1B transfer or your I-140 for the green card, make sure the information is consistent with reality and, as much as possible, with previous filings. Trying to hide or misrepresent the past work history is incredibly risky, as USCIS cross-references everything.
Right, they have the records.
They do. And the other major, do not assume it's harmless just because you got paid your full salary.
Yeah.
We keep saying this, but it's vital. USCIS evaluates your compliance with the terms of your visa status hours, location, job duties, not just whether your employer kept paying you. Getting paid doesn't automatically fix a status violation.
That's a really critical distinction. Compliance isn't just about payroll.
Not at all. It's about adhering to the specific conditions under which the visa was granted.
So bringing this all together, it seems navigating the H-1B landscape, particularly around something seemingly simple like working hours, really requires ongoing diligence. It's definitely not a set it and forget it kind of visa. The details, the nuances, they matter enormously.
They really do. And the final sort of overarching piece of advice is this. Transparency is your friend. Transparency with your employer, transparency in your filings, all backed up by that meticulous documentation we talked about. And when in doubt, get timely legal advice. Doing that is what helps you avoid those major complications down the road during transfers, or especially during the green card process. It's about being proactive, staying informed, and protecting the status you've worked so hard to maintain.
Excellent advice. Thank you for walking us through that complex topic. This has been an incredibly important deep dive. Being well-informed on these kinds of critical personal matters like your visa status, it's just invaluable. Good luck, and we will meet with another subject in the next meeting.